Jeremy, time bar provisions under common law generally regarded as being very hard for the contractor to bring claims. How's the position any different in the Middle East where you work?
It's a slightly different situation because even though you can have a contractual time bar, which on its face might be valid and enforceable, it has to be weighed against obligations like good faith and the illegal enforcement of rights, which are codified under the UAE Civil Code.
So would you say it's easier for a contractor to bring a claim in the Middle East in your experience than it is in some common law countries?
Absolutely. The courts and the arbitration tribunals will have regard to the circumstances surrounding why a claim has been brought late, for instance, and if it's considered unjust to be barred just because of a technical breach, then the time bar will not be upheld and the contractor will be able to bring that claim.
And the provisions under FIDIC contract clause 2.5, for instance, which govern the employer claims and impose an obligation on employers to notify claims within particular timescales as well. Is the position in civil law countries that you have experience, it's similar to common law countries, it's similar to the approach with contractors, so it's a fairly balanced system, or would you say, again, it's easier or harder for an employer to make claims in civil law or common law countries?
I think, again, it cuts both ways, so that if a contractor or an employer hasn't complied with a time bar, it will generally be easier to bring it in a civil law system. In fairness, the clause 2.5 provisions we see quite often not used in Dubai in their standard format, and we're quite often still using 1987 amended Red Book type contracts, so slightly different situation there as well.
And finally, the million-dollar question that we often get asked by our contractor clients when they fail to notify on time. Any top tips for clients operating in the region, in Dubai or the Middle East more generally, for if in situations where they fail to get their claims in on time? What would your advice to them be from a practical perspective?
From a practical perspective, if they failed to give notification in a formal sense, it's trying to identify then if they've informally given notice, for instance. Because if an employer is on notice of a claim, even if the notice hasn't formally been given, there's a reasonable prospect that under a civil law system it will still be taken to be a valid notice, regardless of the time bar issue itself. And certainly that would generally be enough to convince a tribunal that the time bar shouldn't be strictly enforced if some form of notice has been given.
Interesting.